This conference will now be.
Okay, so welcome everybody. Happy New Year. Happy Friday. Welcome to January 20th, 2023. And today we're going to cover what I consider to be a multi-generational issue. So really, no matter what age we are, we're probably dealing with these issues in some regard. And we're going to talk about millennials, the sandwich generation. What does everybody need to know, especially if you're now in a situation where you're finding yourselves needing to help take care of a spouse, parent, a young child, and you feel like, wow, I'm in the middle. How can I do all this? What do I need to know? What are the tools? So today we're going to do our best to cover all these multi-generational issues and help you start your New Year's off on the right foot. So what are some of the challenges that we're seeing? We're seeing that individuals and families are feeling a financial squeeze as parents or other relatives are aging. Money issues are coming up. How are they going to take care of their parents? What is Medicare going to cover and not cover? There's always the emotional stress of taking on more responsibility and the emotional stress of seeing people age, seeing changes that perhaps we didn't expect. So I'm hoping that, you'll use the information you hear today as an opportunity to start having a conversation with those relatives. Open up the dialogue, put yourself and them hopefully in a position where you can share information, you can talk about what's on everybody's mind, and get people to start planning ahead. Now, if we look at statistics, and it's pretty daunting, we've got 11 million caregivers in the United States alone that are between the ages of 18 and 34, which also tells us that our life expectancies are increasing. And statistics are telling us that one of the fastest age groups that are increasing is between 80 and 85 years of age. So we really can't stick our head in the sand like the ostrich and think all these things are just going to blow past us. We won't have to deal with them. They're right in front of us. A lot of times people will call and they'll say, well, why isn't Medicare covering this for my parents' prescription drugs? Or, how do I get some sort of a Medigap policy or a supplemental policy to help between what Medicare is going to cover and their 20% responsibility? So the time to start doing this really is before medical issues arise. And so today we're going to talk about some tips and tools that everybody can get in place now just to be better prepared when the issues come up. So I think a good place to start is understanding some things you want to look for. What are some of the signs that might cause you to take a step back and think, is something changing here? What am I noticing? So we're going to define and talk about two important things that all of us do, but we probably take for granted. The first one are what we call activities of daily living, and the second one is what is called instrumental activities of daily living. With activities of daily living, these are things we just take for granted we do. We can feed ourselves, we can do meal preparation, we groom ourselves, we bathe ourselves. We transfer pretty easily probably from a bed to a chair or vice versa. We're able to dress ourselves. But if people are starting to have physical changes, the likelihood is you're going to start to see changes in these areas. And if somebody is starting to experience some cognitive changes or loss in memory, you might see that it's taking them longer to initiate activities of daily living, or they may need assistance. So if you see changes with activities of daily living, this might be one of the first clues to tell you, hey, we need to sit down as a family, we need to talk about this. Maybe we need to get some home health services in to take care of mom or dad or grandma or grandpa. The other thing that could tip us off are changes with instrumental activities of daily living. And these are more functional things. These are things that are going to show us, is the individual able to take an idea, implement it, and carry it through? So for example, using the telephone, using the computer. If you hear your relative or your loved one say, I couldn't find the phone numbers in the cell phone, I think I deleted them. But then you go to look at their cell phone, and sure enough, the names and phone numbers are there under contacts. That could be a clue something's going on cognitively. And it might be a good time to start by scheduling a checkup with the primary care physician, see what that doctor thinks might be going on. That doctor may then refer you to go see a specialist, perhaps a neurologist, who's going to do testing. You might say, hey, I noticed when I'm visiting you that there are unopened envelopes on the kitchen counter or on the dining room table. What's happening? Why aren't you opening the envelopes? Especially if you can see that the envelopes are, bills from vendors. That might give you a clue. Hey, maybe something's going on. They're not paying their bills on time. Maybe they're not reconciling their financial statements. And unfortunately, what COVID created, which was putting all of us into a situation of staying in our homes, being afraid to venture out, even being afraid to go to a relative's home, there was a lot of alienation. And we all know now that that alienation did create situations including depression. And so if we weren't seeing our relatives as often as before COVID, we could have been missing these kinds of warning signs. But we want to know about them, and we want to look for them now going forward. So if you think that your relative might need the guidance of an elder law attorney, and it doesn't have to be in Florida, it could be anywhere in the country that they live, what is that person going to be able to do for them, and how are you going to find somebody out of the state where you live? So there is a wonderful resource available on a national level. It is called the National Academy of Elder Law Attorneys, and you can go to their website. It's naela.org, and they have a directory that you can start to search through, first by state, and then once you're in the state, you can see by geographic area. And that's a wonderful way to start trying to get an elder law attorney to provide guidance and help your relative. So what can that person do? Well, every elder law attorney is going to perhaps specialize in a few areas of practice, and that will also be listed in the NAILA directory, but you certainly want to ask that question when you first contact the office. They should be able to advocate and help you navigate through the healthcare system, understanding Medicare. What does it provide? What are the limitations? What is it not going to cover? What Social Security benefits is your relative entitled to? Are they perhaps entitled to more either because of a disability or because a spouse of your relative recently passed away? They should hopefully be able to guide you about veteran benefits that also might be available. Again, we want to explore all the financial resources to help provide the care that's needed. The elder law attorney should talk with you and your relative about creating a legal plan that's going to cover financial decisions as well as medical decisions. And we're going to get into this today in greater detail. The hope of having that plan is, first of all, that your relative will choose the people that she or he trusts, that feel that they are able to handle making decisions when the relative needs it, so they keep privacy in their life, and they avoid having to do a court-supervised guardianship. If, however, by the time you realize that your relative needs assistance, it might be too late. And what I mean by too late is they may not have the mental awareness to sign a document and understand what they're signing. Then the lawyer should be discussing with you guardianship, which would be the next way for you to have legal authority to make medical and financial decisions for your loved one. And most importantly, the elder law attorney should be a good listener, be well versed in these areas, and help guide you to what's going to be the best option, the best plan for your family and your loved one. So, what are the other things you're going to look for that might say to you, now is the time I should be making an appointment for my aunt or my uncle or even myself? So people tend to think there's a magic age that we get to, and that's when we should go to the elder law attorney. And it's a little bit of a fallacy that we are called elder law attorneys. We should probably be called something like aging attorneys or something to indicate that really aging happens from the minute we're born. So from the time we become adults, whether it's age 18 in Florida or 21 in another part of the country, that's when we want to start talking about what should I know about? When do I need an attorney? So it could be that a family member has a disability and they need help accessing government benefits, or they need to have documents put in place. Today we're going to touch on what if you have a minor age child, somebody who's under 18, or a child about to turn 18, become a legal adult. What do you need to know for them? It might be that the time to go see an elder law attorney is when a spouse passes. What do I need to change? Do I need to update my documents? What do I tell the financial institutions? Or it could be that there's a recent divorce that's occurred. And so the same analysis needs to be looked at. So timing is really important. So if we can get away from this idea that we should only do these things when we're much older, we're going to be much wiser and we're going to have more options available to us. So that's why timing is so important. In the law, as in medicine, there has to be a certain level of understanding for the client to be able to make decisions. It's not a matter of can the client hold a pen in their hand, and if you say, here, Mom, I want you to sign here, that they can do that. It's about, does Mom understand what she's doing? Does she have questions that she wants to ask? Is she willing to sign the document? So the most opportune time is when people are physically healthy and when they're mentally competent. That allows us to do the planning we're going to talk about. So we save money because a guardianship is very expensive compared to doing the planning beforehand. We avoid being in a crisis situation where maybe we're not thinking as clearly, or we may not have as many options left. And the other benefit of doing the planning timely is that people maintain their independence. They're able to express their wishes and their desires and maintain their privacy and their dignity. And I think all of us would agree we want to be in control of making decisions as long as we possibly can. But most importantly, we want the people we trust to know what our preferences are because we are trusting them to protect us and carry out those preferences. So the documents we're going to talk about today involve naming somebody we trust as a fiduciary. And this is a really important word, and it simply means that we are putting our trust in this individual. We're giving them a responsibility to act in our best interest, not theirs. So we're going to talk today about naming a healthcare surrogate, naming a power of attorney, and all those roles, all those responsibilities are what we call a fiduciary. Now, a fiduciary can be a person, and sometimes we may not have a family member who's alive or that we trust. It could certainly be a best friend. In some situations, financially speaking, we might want to appoint a professional. Maybe we want a trust company to be our personal representative or be our trustee over our trust. There's lots of different options. What's important is that the options are tailored to meet your needs, because your needs are very unique, they're specific, and they're going to be different than your friend or your neighbor. So make sure that you have a plan that's tailored to you. There's no such thing as a cookie cutter. So one of the first, and I think very important documents that everybody over the age of 18 needs to have is called the durable power of attorney. Now you see I underlined the word durable, and that's really important because it means that the document is intended to work for us even when we're not well. We could be incapacitated, we could be sick temporarily, we might have a disability, but it allows our financial decisions to continue to be made. Life does not stop. It doesn't get put on pause. And if I'm a very visual person, I think of advertisements that I like, I think of commercials. And back in the 80s and 90s, there were these wonderful commercials about the Eveready battery. And their advertising agency came up with, remember the little pink Eveready bunny? He was in every commercial, and sometimes they had him going through water coming down or fire. And so that's always stuck in my mind as what the word durable means. It gets you through that time, no matter how horrible it is, and you come out the other side. And that's exactly what the purpose of having a durable power of attorney is that somebody we trust handles making our financial decisions. It could involve paying our bills on time, speaking with our investment advisor, making investment decisions. Could be signing a tax return, which is going to be due April 15th. What is really important to get from this is we're not giving that person, that fiduciary, ownership of our assets. We're not taking the assets out of our name, it's still in our name, but we're giving them legal permission to handle it for us. A lot of people tend to think, oh, when I'm sick, I'm just going to send my son or daughter to the bank and they'll identify themselves and they'll say, you know, they're my daughter, they're my son, and the bank will give them access to the account. And that's really farthest from the truth. You know, we live in a world today with a lot of privacy laws, which should be in place. And if your son or daughter tried to walk into your bank and showed their photo ID and said, you know, my mom is Stephanie Schneider, the bank officer would say, okay, that's very nice, but please show us either a durable power of attorney for your parent or show us legal guardianship papers. And without either of those, the bank officer is not going to speak with them, is not going to release any information. So this is giving permission, it's not giving ownership. Now, prior to 2011, we had the option in Florida of writing for clients what was called a springing durable power of attorney, which meant it was not effective when the client signed it. It was only effective when the client was actually incapacitated. And in order to know when that happened, we would need an affidavit signed by the doctor. Well, in 2011, the law changed in Florida. And unfortunately, we are no longer allowed to write a springing power of attorney. So that means that when you sign it, it is immediately effective. Now, for younger people, that might sound a little scary, and you might say to yourself, well, wait a second. I don't want my child or my niece or my nephew to start making decisions for me. Maybe I shouldn't sign this. Here's the way you want to approach it. You should sign it, because if you don't and then you become incapacitated, it's too late to sign it. So what you want to do is tell your child, tell your niece or nephew, I did this. This is where you can find it when I'm incapacitated. but you don't give them the original and you don't give them a copy, because under the new law, the copy is considered as effective as the original. Now, the other thing that changed with the law in 2011 is what we refer to as the superpowers. So in the document, we must have you decide, are you giving your fiduciary permission to make these kinds of high levels of financial decisions? And the superpowers are things like the ability to create a trust for you. Could be a trust that maybe has tax protections. Maybe it's a trust to help you get Medicaid benefits down the road. Another superpower is whether you want to give your fiduciary the ability, when you're incapacitated, to make gifts of your assets. So you want to think about, have I had a history of making gifts to family members, maybe on birthdays, holidays, special occasions like weddings? And would I want that continued? Or do I have a history of making charitable donations or tithing? Do I want to give my fiduciary the ability to continue that or not? So these are some of the really important superpowers that need to be included and will either be authorized by you or you'll decide not to authorize them. Now, because the law changed, and I'm telling you the document is effective as soon as it is signed, you might be thinking, okay, so when I'm actually unable to make my financial decisions, how does my fiduciary present the document? How are they going to have their authority recognized? So in Florida, our law says that any financial institution can ask your fiduciary to sign an affidavit. And the affidavit primarily protects you and the financial institution, because in that document, your fiduciary is saying that, first of all, you're still alive, you're not deceased. Why is that important? Well, it's important because the power of attorney only works while we're alive. Once we're deceased, it served its purpose, it ends. We're not supposed to use it anymore. The next thing the affidavit will say is that there is no guardianship pending for you. And that's important because if somebody were to file a guardianship, it temporarily suspends the power of attorney from being used. So your agent, your fiduciary, is signing this affidavit that they have knowledge of these things. Once it's signed, then the financial institution will have everything reviewed by their legal department and should approve it, and then ask you to sign a signature card, provide photo identification, and then give you the access to handle the assets. Now, we have really two sides to our personal lives. If we drew a line down the middle, I would say one side is our financial life, and the other side is our healthcare, our medical, our where am I going to live, our making residential decisions. So one is not more important than the other. We want to really treat each equally and make sure we have a balance. So to create that balance, it's important to have a document called a designation of healthcare surrogate. And this is a way we name someone we trust to make medical decisions for us. Now, you don't necessarily want to name the same person to be both your financial decision maker as your medical. You want to think about who has the skills, who has life experience that is going to put them in the best position to make the type of decisions needing to be made. So you might name one person as medical decision maker and an entirely different person as financial decision maker. But whatever you choose to do, it's very important that you, your parents, your young adult children, always name an alternate. Because the one thing none of us have is a crystal ball. We can't look into the future and say, is the person I'm naming as my first decision maker always going to be healthy? Are they going to outlive me? We never know the answer to that question. So we want to name at least one, if not two alternates. So that becomes our management plan. It becomes our fallback, our plan B. You know, if you think about it, if you ever buy a ticket to go see a play or a musical, they don't cancel the play or the musical simply because the lead actor or actress gets sick or has laryngitis. They have an understudy. And so that's the same approach here. We have an understudy. If, God forbid, the first person we named, when the time arises, they can't serve, they can't step forward. So our document doesn't fall apart, our plan doesn't fall apart because we've got a backup plan that we thought through. So what are the kinds of things that our medical decision maker can do for us? Well, think in terms of what do? You schedule your medical appointments, you go to your doctor. When you're checking in at the reception desk, they might ask you to sign a HIPAA authorization form. Those are things that your surrogate is going to do for you. Let's say you're in the hospital and you've got a diagnosis and your surrogate says, you know, I'd really like to get a second opinion. Maybe I'd like to have you transferred to a hospital that specializes in that diagnosis. I'd like you to get a second opinion, and then maybe we'll do the treatment at that specialist hospital. Well, they might need access to the hospital records where you are. They can have that access. They can give the authorization. So think in terms of that those are the things that they can do for you if you're unable to speak, if you can't communicate, if perhaps something is happening cognitively, even on a temporary basis. So in 2015, we did update this law, which was well needed, and now we can offer people two more decisions that can be written in their surrogate document. The first decision is when it will be effective. Now, you heard me say the power of attorney is effective immediately. There's nothing we can do about that. But here, with the healthcare surrogate, you can actually choose, do you want it effective immediately, or do you only want the surrogate to be able to make decisions when your doctor examines you and determines that you lack the ability to give informed medical consent? So I think that's great because it gives us choices. The second decision you have to make is when do you want to give your surrogate the ability to access HIPAA-protected medical information? And again, you have the same choice. You can give access immediately, or you can choose to only give access if the doctor determines you lack the ability to give consent. Now, it doesn't mean you have to choose the same answer for both of these questions. You could say, for example, I only want my surrogate to step in when my doctor determines I lack the ability to give informed medical consent, but you can choose to give your surrogate the ability now to access HIPAA information. So sometimes I find with some of my older clients, they're not ready to let their surrogate step in, but they'd like that person to be able to talk to the doctor, to be present when they're meeting with the doctor and they're talking perhaps about test results. So it can be worked in a way that meets your needs. Now, so far we've talked about two important legal documents, and they're important for you, your parents, and children that are over 18. So let me just mention, it comes as a little bit of a shock to parents to find out when their children are perhaps in college or in the military that legally they can no longer make financial or medical decisions for them. A lot of times what I hear is, what are you talking about, Stephanie? I'm paying, for the car insurance, or Stephanie, I'm paying the room and board at college. Well, in Florida, our children become adults at age 18. And so legally, we no longer have access to their medical information. We can't make medical decisions. So usually the next question I get, and I'm surprised nobody's asked it yet, is, well, what if my child's in a car accident? Are you telling me that I can't make their medical decisions at the hospital? Well, the simple answer is, if it's an emergency, under the law, the doctors will do whatever needs to be done. But if there's continuing decisions outside of the emergency and there are no legal documents in place, you might be told by the hospital risk manager to go get a guardianship. And so we really want to avoid being in that position. So I do recommend, before we send our young adults off to college, to study abroad, to go into the military, wherever, at least get them that designation of healthcare surrogate. That's really important. Now, when they're done with school and they're starting to work, they're going out, they're developing careers, it's probably a good idea then for them to also have the durable power of attorney. Because if they were to become incapacitated, if they had a car accident, you need that power of attorney to be able to access bank accounts, to pay their bills, to do whatever might need to be done on a temporary basis. So just keep that in the back of your minds. Now, for your parents, for your aging relatives, you might be concerned about, well, how are they going to pay for long-term care? What if somebody has a stroke? What if somebody has a heart attack and it completely changes how they were living before? You're questioning, are they going to be able to stay at home? And if so, what kind of assistance is needed? If they're married, we certainly don't want the spouse to get run down as the primary caregiver. And if they're not married or they're widowed, it's even more of a challenge trying to figure out, how do we provide services? How do we make the home environment safe? So we're going to need to explore government benefits that could be provided either through the Medicaid agency or perhaps through the Veterans Administration. So today I'm just going to share a little bit of background with you on resources that are available to pay for long-term care needs if your relative did not purchase long-term care insurance when they were younger and able to. Now, Social Security will provide to people either retirement benefits or disability benefits. Retirement benefits, could start prior to age 65. It is recommended that you wait until 65 years of age to get a higher amount. And if you can wait even past 65, you get compounded interest each year on what will be your Social Security retirement benefit. If you are younger than 65 and you're working, but something happened and now you find yourself, or your relative finds themselves, unable to be employed in the same position, then it might be the time to apply for Social Security disability insurance. Getting disability is simply getting your retirement early. You're accessing your retirement benefits prior to age 65. Now, to prove that you're entitled to disability, they're not going to look at finances at all. This is not a financial-based issue. So it doesn't matter what somebody has in the bank. They could be a millionaire. What they're looking at is, do you have 40 quarters of payroll taxes in the system? And that means somebody needed to have been paid legally, not under the table, because if they're paid under the table, it means nothing is being reported through Social Security to IRS. 40 quarters basically is the equivalent of 10 years of work history. So for every 3 months, you earn a quarter. So in a year, you have the potential to earn 4 quarters. The other thing they're going to look at is, does your illness or your diagnosis prevent you from being substantially gainfully employed? Now, they will ask the person to give consent to access medical records. And if there is a concern, Social Security may have their own doctors review those medical records and possibly do an independent examination. It can take, unfortunately, several months to get a decision on a Social Security disability application. However, there are some exceptions. Social Security has a list of what is called compassionate allowances. This is a list of certain illnesses and diseases that do not require Social Security's doctors to do their own independent examination. When the person applying or whoever's applying for them submits the medical records that show the diagnosis, if it's on the list of compassionate allowances, they will treat it as an emergency. It gets immediate priority and they are immediately approved. So there's no delay in disability benefits. Now, if somebody's been approved for Social Security disability benefits, after 2 years of getting those benefits, they will start to be entitled to Medicare Part A. That would normally, if we were not applying for disability, we're applying for retirement, that would happen at retirement age. But it can happen earlier with the disability. Now, again, there's an exception. You don't have to wait the 2 years if the person is diagnosed with end-stage renal failure. There has been some discussion of there being bills introduced into Congress to try to create exceptions for other diagnoses so that people do not need to wait the full 2 years to get Medicare Part A. So stay tuned and we'll see what happens with that. Now, there could also be access to veteran benefits for your older relatives. So you would want to ask your family member, did you serve in the military? Did you serve during a declared period of war? Now, you can go to the VA website, it's va.gov, and they will tell you what Congress has determined are the beginning dates and the ending dates of each period of war. The one that is probably most confusing has to do with the Vietnam War, and there are actually 2 periods of time listed. If your loved one did serve at least 1 day during a declared period of war and they were honorably discharged, then there's the possibility they could be entitled to what is called aid and attendance benefits. This is a financial benefit that is paid for the purpose of helping the veteran and their spouse stay safe in their home environment, which means that they could use the money to pay for home health services or other things they may need. Now, this is different than Social Security disability because here the VA is going to do a financial review. So they are going to look at income and they're going to look at resources. With the income, if we're able to show that the veteran is paying and incurring out-of-pocket medical expenses not covered by health insurance, we can take the position that that is reducing their income, which shows even greater need that they have for the VA to provide financial support. If the veteran gets approved for this benefit, then the spouse is also potentially eligible for financial support as well. However, if the veteran is healthy, doesn't need the assistance, but it's the spouse who has a diagnosis or an illness, unfortunately, we cannot get them this benefit until the time that the veteran needs the assistance. So just be aware. Now, Medicaid and Medicare are not the same thing. They can tend to be confusing because the words look similar. Medicare is really designed as a healthcare system for short-term illnesses. That means somebody goes into the hospital and then they go home. Somebody needs to go see their doctor. Maybe they need to get a walker or a cane, what we call durable medical equipment. But Medicaid was designed to be for long-term, chronic illnesses, long-term needs. So we're using Medicare when somebody turns 65. You get Medicare Part A, you buy in, you pay a premium to Medicare Part B. But if you need long-term services, Medicare is going to have limitations. They're not always going to pay past a certain number of days for hospitalization, and traditionally they pay for no more than 99 visits a year for home health services. So we're going to take a look at Medicaid for a couple of minutes, talk a little bit about what can be done to plan if somebody needs Medicaid. And excuse me, it looks like my slides may have moved out of order. Whoops, I'm sorry. Let me go back. So to qualify for Medicaid, a person needs to have limited income and limited resources. The person who needs the Medicaid, regardless of their marital status, would need to have in their name no more than $2,000 of resources. Resources are things like our bank accounts, investments, stocks, bonds. Now, there are certain resources that won't count in that equation. So Florida doesn't count the home, they protect that. They don't count the car, and they will not count an IRA or a 401k plan as long as the person applying for Medicaid is taking minimum distributions on a monthly basis. If they're married and the spouse is healthy, the spouse is allowed to have a greater amount of assets. That figure, though, doesn't stay stagnant. It actually changes every calendar year in January. And so figures I'll tell you today are going to be different a year from now and 5 years from now. But currently that spouse is allowed to have in their name a little over $140,000. Now, if we find that a person needs long-term care and they want to access Medicaid benefits, and perhaps they have more assets than they're permitted, we might look at a couple of planning tools, which could include creating a special needs trust and putting those assets into the trust. But to do that, the person has to be under age 65. That is the legal cutoff. So in a minute, we're going to talk about another kind of trust that's available for anybody of any age, even if they're over age 65. Now, to use a special needs trust, we have to establish that there is a disability and that they're under age 65. The goal of putting the assets into this kind of trust is to make the assets last as long as possible and supplement whatever Medicaid is going to pay for. So, for example, where Medicaid perhaps would pay for a certain type of wheelchair, but you may want something that is built over in Europe and is going to be better for your loved one, you would pay the additional sum through the special needs trust. So we're looking to see how can we create quality of life and quality of medical care for people as they age. And so as long as the funds are used for that individual and not anybody else, it's like giving somebody a blank canvas with different color paints and paintbrushes and saying, paint what this would look like for you. So for some people, quality of life might mean the ability to travel or have their loved ones come and visit them. For other people, it might mean using special needs trust assets to try different types of treatment that perhaps are not yet approved by the FDA. Years ago, I would have clients who would go outside the US for stem cell therapy. And that's what they would use special needs trust assets for. So it's about using it, tailoring it, designing it for the needs of the individual. Now, we've been able to use special needs trust since 1993 when it became a federal law. And you know we don't get anything for free from the government. So in order to be able to use this trust, we have to be willing to include language in the trust document that says when the trust beneficiary passes away, if they've been receiving Medicaid assistance, we have to first repay Medicaid what Medicaid spent. from anything that might be left in the trust. And conversely, if there's nothing left in the trust, then there's nothing from which to repay Medicaid. And nobody else has any kind of liability to repay Medicaid. It would only come from the special needs trust. Now, what if somebody is over 65? What is their option? Well, one option we can consider is called a personal service contract. And this can be used if somebody is providing services to the older adult, the person with the disability. Doesn't necessarily have to be a relative, could be a friend, could be a neighbor, but their services have a value. They're helping to take care of this person. And if they weren't available, it would mean that the older adult may have to call up a home health agency for assistance. So what we're doing is we're finding a legal way to compensate the person who is providing the services, the caregiver. We're putting it in writing. We're saying, here are all the things this person is going to do. It could be that they're doing the food shopping, they're doing the meal preparation, they're doing laundry services, they're arranging transportation to go to doctor's appointments, they're communicating with the doctors and overseeing the medical care that needs to be provided. Could be that they're also handling the bill paying. Maybe they're taking care of what needs to be done in the house or outside the house. So those are all things that are considered viable to be compensated for, but it needs to be put in writing and it needs to be signed by the care provider and the person receiving the care. So this is one way to be able to help qualify for Medicaid without it appearing to be a gift. And wherever you are in the country, the federal Medicaid law does say that if you've given away assets within the 5 years of applying for Medicaid, that would delay qualifying for Medicaid. So this is not gifting, so we don't have a problem with the look back period. Now, what if you find yourself in that sandwich generation? You've got an older adult you're caring for, you have young children, and you're in the middle. You're trying to take care of yourself, your older adult, and your child. So Florida has some very good legal tools that help parents who have a child under 18 that everybody should consider. The first one is called a designation of healthcare surrogate for a minor. Now, you heard me talk a little while ago about a surrogate for us as adults. We can actually name a surrogate for our children if we're going to be away and unavailable and a medical issue arises. So let's say we're traveling on business or we're traveling on vacation and we ask grandma or grandpa to take care of our 8-year-old and something comes up. Well, this allows grandma and grandpa to temporarily make the medical decisions until we either can be reached or we return home. So this is something I strongly recommend parents of minor children do. The other tool that's available is called a declaration of pre-need guardian for a minor. This is a way of designating in writing a guardian should we, the parent, become incapacitated or die unexpectedly. The nice thing about this document is it gives us the control of deciding who that person should be. And it creates the legal presumption that this is the person that a judge should appoint as the guardian, as long as that person can pass a background criminal investigation that the court conducts. So you want to think about a guardian, a person who would the child live with, who would make the school decisions, medical decisions, and you would name a guardian of any assets that the child might inherit. Again, it doesn't have to be the same person. You might think one individual is best suited for handling the inheritance for your child, and a different person might be better for raising the child. So you can have two different individuals serving in those two different roles. So when you're looking for an elder law attorney, they're not just going to be a resource of what the legal options are available. They're going to be able to perhaps connect you to life care managers who are nurses and social workers that you might need to look to help you find healthcare professionals. You might want that life care manager, if you're not close by to your relative, to be checking in on your loved one and contacting you and just giving you an update how they're doing, any issues that they're spotting. Elder law attorneys can connect you with support groups that are locally, nonprofit resources, senior centers. So there's lots of resources in the community that we can connect people with. Because the reality is people are multidimensional. They don't just have a legal issue. There's so many other parts in our lives. There's social, there's medical, there's financial. So we want that big picture to be balanced. So just a couple of tips of how you might want to try to approach these conversations with your parents or older relatives. And I like to think of things in terms of acronyms. So I use the word CARE, and the letter C stands for approach the conversation with compassion. Realize that this kind of conversation can be scary for some people. You are making people realize that we're not going to live forever and we may not age the way we expected to. So I like to start with having a compassionate approach, that you're caring, that you want to be helpful. The A stands for acceptance. Acceptance simply means you might not get the reaction you're hoping for the first time that you have this conversation. So it's important to validate how your relative is feeling and accept that that's where they are at that moment. It doesn't mean that they're going to stay in that position forever, but it might take several small conversations on these topics before you can get them to be willing to take a step forward. The R stands for respect. Show respect for whatever decisions that they make and just let them know you're there to help them along the way and help them figure out what's the best decision for them. And lastly, the E stands for empathize. Empathize for where they are now. You're in a different place in your life. It may be very hard for you to imagine what it's like to be that age or what it's like to be alone or without a spouse. But you can empathize with how they feel at that moment. You can repeat back to them what you heard them say, that it's very hard making these decisions when their husband or wife is not there. So if you've ever heard this adage, how do you eat an elephant? You do that one bite at a time. It's like, how do you peel an onion? You peel the top layer and lo and behold, there's a layer underneath and then there's another layer. And that's why I say these conversations are not necessarily going to take you from beginning to end in one sitting. It can take time, but I encourage everybody to start your new year, and if you're going to make New Year's resolutions, by at least starting the conversation. You can also offer to be with them when they go see an elder law attorney. So here are some tips for how you choose an elder law attorney. What are the questions you want to ask? So you can start by asking if the attorney is board certified. What does that mean? Well, it's the same as in medicine. Doctors can specialize in different practice areas. They can be board certified in cardiology, study of the heart, or in another area. Law is the same way. Law has developed to a point where we cannot be general practitioners and know everything there is. So board certification shows that the attorney has specialized, that they've reached a certain level of experience, and that they continue their education to be able to provide the best information and resources to the client. You should ask, is there a consultation fee? How much is it? Will that consultation fee be applied if we hire you for the services? Will you give us your proposal in writing? Will you write a letter after the consult? Giving us your recommendations, because it can be overwhelming during that meeting. You might not remember everything the lawyer says, so it's great to ask, will you put it in writing for me and my parent or my aunt and uncle? You can also ask for a reference. Ask the lawyer, is there a satisfied client that would be happy to speak with us about their experience? And I already mentioned to you that the NALA organization is a resource if you're looking for an elder law attorney in another state or even in another country. Think about how your initial customer service experience is on the phone, dealing with the attorney's office. Are you comfortable? Do you feel that the information that's going to be shared is going to be kept confidential? That will tell you, and that will help you decide, is this the office that I want to make an appointment with? So as you prepare and help your relative prepare for that consult, I suggest you do a couple of things. First, organize the paperwork. And this is something that your relative might be good at and they may not be good at. So you want to leave yourself enough time to help them. You want to have a good understanding of what the sources of income are, the resources, and any liabilities, whether they have credit card debt or medical debt. And most importantly, before you go to the meeting, write down questions, concerns, even fears. Sometimes your relative might say, I'm really afraid of running out of money. What if I outlive my money? What happens then? And most of all, help them to write down their goals. What is important to them? What do they want to get out of the rest of their life? How can the lawyer help them? And the lawyer will know based on what those goals are. If your loved one has a hearing impairment, a visual impairment, make sure they bring the glasses and the hearing aids so they can hear everything, they can participate. And it is important in the meeting with the lawyer to be honest about things that maybe your family member might be a little embarrassed about. Maybe one of their family members that they want to leave an inheritance to has a disability, special needs, maybe an addiction, or maybe they just are a spendthrift. They're not fiscally responsible. You want to share this information because it's going to help the attorney guide you and your relative. The attorney might say, if this person's not fiscally responsible, let's not name them in the power of attorney. That would not be a good idea. So the more information you share, the better the attorney is going to be able to guide you and create a tailored plan. So at this time, I'd like to open it up for any questions anybody has. Feel free to unmute your microphone. We do have a wonderful library on the website of recorded webinars, so feel free to look at that at your convenience. And as I said, we are recording today, so that will be up and available next week. And also on our website, we have a gift certificate for people to use for a complimentary 20% discount on an estate planning consult or a long-term care planning consult. So I'd like to thank everybody that took the time to join me today. Thank you. I hope your new year is off to a good start and that today's topic helps motivate you to take that step forward.
Thank you very much.
I see there is one message in the chat box. Let me see if I can see that. No, I can't. Okay. Well, I'm going to say goodbye and thank you for joining.